Let's move into the second finger of libel, that is identification. We have to have a plaintiff for a libel suit, and the plaintiff is the person who alleges that a published statement damaged the plaintiff's reputation. In identification, we get into the matter of who can sue. It's well established in the law that the publication that is alleged to be libelous must be of and concerning the plaintiff. We can be identified in a number of ways, one by using your name, or a photo of you or a video of you, but identification also can arise when there's some special attribute that lets people identify the person who's being written about. So normally in a class I would survey the class and I would say a student who shall remain nameless but who is wearing Air Jordans has a loathsome disease. And of course students would look down to see what shoes they had. I would be looking at one student wearing Jordans when I said that. I said, so we have a plaintiff. But then I said, how many other possible plaintiffs are there in the room? And other students would raise their hands. So you have to be careful. If you vague up the identification in the hopes that the plaintiff that you're talking about won't sue, you may just be opening the door to other people. A key fact in identification is that it's not what you intend, but what the audience perceives. It doesn't matter that you were writing about Joe Smith when Joe Dokes sued you for libel, as long as the audience thought that Joe Dokes was the person you were writing about. Here we have a couple of cases. Washington Post versus Kennedy. The Washington Post ran an article about an attorney who had been arrested and was facing charges in the District of Columbia, Harry Kennedy. Well, after the story came out, Harry Kennedy, who was a lawyer in the District of Columbia, sued the Washington Post. The Washington Post said, no, we were talking about Harry Kennedy from Detroit, not Harry Kennedy from the D.C. area. But the court found that most people who looked at the article thought it was Harry Kennedy from the District of Columbia, and on the basis of the audience's perception, they allowed the suit to go forward. The Washington Post versus Kennedy is based on an older case out of England called Jones versus E.F. Hulton Company. Hulton published the Manchester Sunday Chronicle. It had a feature called Our Roving Correspondent. One week, Our Roving Correspondent told the story of Artemus Jones, who was a businessman, a member of the Church of England, who was married, and, the thing that made the story interesting, would kiss his wife goodbye, take the train to the coast, take the ferry to the continent, take the train to Paris, and whoop it up with French babes. Much of the article was about the fun that Mr. Jones was having while his wife would not know what was going on. After the article comes out, Artemus Jones, a real member of the Church of England, a real businessman, a real person who's married, starts getting strange looks. He asks people what's going on, and they point him to the article. He sued E.F. Hulton Company. At trial, the publisher made a painful admission. Our Roving Correspondent was fiction. They didn't have a roving correspondent going around England looking for interesting stories. They had people who would just make up things and put them in the paper under that headline. The Jones in the Our Roving Correspondent story was a complete fabrication. The people at the Manchester Sunday Chronicle said, then Mr. Jones can't sue us because we weren't writing about him. But the English courts made it very clear that because the audience perceived the subject of the story in the Sunday Chronicle as being Mr. Jones, he was a libel plaintiff. He won more than £1,000 in damages against the Sunday Chronicle. Remember this, if people recognize the plaintiff, you have identification. Let's move into a complicating area, that of group identification. What happens if we libel a group? CBS News once did an uncomplimentary story about hunters in Michigan, and a hunter in Michigan filed suit against the network, claiming that he and a million other Michigan sportsmen were the plaintiffs. Well, that was too many, and the court tossed out the lawsuit. But let's take a key case in group identification, that of Neiman Marcus versus Late. Neiman Marcus, of course, is the upscale department store. It was the place you went to if you struck oil. Late was the publisher of kind of a sleazy book that was written at a time when we didn't say the word sex because it was too adult. Late published USA Confidential, which was the story of a road trip across America where the authors told you where to go to find girls who would have sex with you. They got to the Dallas entry, and the authors wrote, Neiman Marcus has 9 high-fashion models. They're all prostitutes. Expensive, but high-fashion models and very pretty. Then it said, more than 300 saleswomen who work in the regular store Well, they're all prostitutes too. They will charge you less money. And they said the 25 fellas in the menswear department are the heart of the Dallas fairy community. Back in those days, fairy was a term used to refer to gay men. All of the high fashion models sued for libel. More than 200 of the saleswomen sued for libel. More than half of the salesmen sued for libel. The court allowed the lawsuits of the high fashion models, the 9 of them, to go through. Now, these were individual lawsuits. There were 9 causes of action there. It allowed each individual salesman to move forward with his suit. But they denied the lawsuits, the libel suits, for the saleswomen, saying that 382 women constituted too large a group for any one person to have been identified with particularity. That's a key concept. If the group is small enough, then people will know who's in the group, and each individual member will have been identified with particularity. That's going to be important to us in our next case, Fawcett Publications versus Morris. Fawcett Publications published some books. They were trying to do investigative reporting. Morris was a member of the Oklahoma football team, the Sooners at OU. An author wrote a book about the use of illegal drugs, performance-enhancing drugs in collegiate sports. He made the case that the Sooners, who had been national champions for 2 years, had been using performance-enhancing drugs, most significantly methamphetamine. Out of the members of the football team, and there were 55, only one sued for libel, Mr. Morris. Fawcett Publications wasn't concerned. They said 55 people is too large a group for any one member to have been identified with particularity. What they didn't count on is that it was the Oklahoma Supreme Court, whose membership is made up entirely of graduates of the OU School of Law, was going to hear the case. The Oklahoma Supreme Court found that Mr. Morris had been identified with particularity because everybody in Oklahoma knew all the members of the football team during the championship years. The size of the group going to be important, but also the attributes of the group. If the group is sufficiently famous that you can name all the people, then it doesn't matter how large the group is, because each person will have been identified with particularity. But if the group is large, and it's kind of an amorphous blob to you, you may be able to pick out 1 or 2 of the key players or members, but everything else is a blur, then there has been no identification with particularity. Just to let you know, there is no hard number. There is no bright line rule that says X number is enough and X plus 1 is too many. It's all going to be based upon the circumstances. Importantly, only the people who've been identified are able to sue. So your parents can't sue for you. Your significant other can't sue for you. Only the person who's been identified in the defamatory statement can sue. Dead people cannot sue. In 26 states, the death of a plaintiff ends the lawsuit. 14 states say the suit continues, and 10 states have no cases on the matter. California says the suit will go forward, but only if the plaintiff has filed suit before his or her death. Let's move on to the next finger, the middle finger, the naughty finger. That is defamation. Here's an important thing. To start off with, defamation, the defamatory statement, must be wrong or false. It also must be believable, and it has to be harmful to reputation. If it is not those things, then it's not defamatory. The requirement that stories be false comes from the case of Philadelphia Newspapers versus Heps. Justice Sandra Day O'Connor wrote the opinion for the court, saying that if the story, the publication, touches on a matter of public concern, then falsity has to be proven. Let's move on to the next one, believability. Larry Flynt and Jerry Falwell did not like each other. Larry Flynt considered Falwell to be a phony. Jerry Falwell considered Flynt to be a threat to American morals. One day, Mr. Flynt published this ad parody. Now, Campari is an alcoholic beverage, and it wasn't particularly popular. It started an ad campaign based upon double entendre. You would have actors and actresses talking about their first time to have Campari, but it was couched in a way to make it sound like it was the first time they had sex. An actress like Jill St. John would say, well, the first time I tried it, I didn't like it, but then my friends talked me into doing it again, and the more I did it, the more I liked it. And of course, people would be sniggering as they read the advertising matter. Larry Flynt took a Campari ad and made a parody of it featuring Jerry Falwell. The quality of the reproduction is deliberate. In the Campari fake ad, he had Jerry Falwell talking about the first time he ever had sex. According to the ad, the first time he ever had sex was with his mother in an outhouse when they were both drunk on Campari. Incidentally, there was a goat in the outhouse as well. Jerry Falwell, he filed an infliction of emotional distress, libel. During the trial on libel, Mr. Falwell was asked whether anyone would believe that he had sex with his mother the first time he ever had sex. And of course he said, no, that's absolutely ridiculous. He compared his mother to being the next thing to a living saint on the earth. By saying it wasn't believable, it wasn't defamatory. So in that case, the fact that it was not believable and the victim of the libel said it was not believable meant that the libel claim went away. Don't worry, Mr. Falwell won a significant award against Flint over the infliction of emotional distress. Ultimately, that was overturned by the Supreme Court. New Times versus Isaac. Now, this is not the New Times in San Luis Obispo. This is the New Times in Dallas. What had happened was a judge and the district attorney sued over a story about putting a 6-year-old in jail because of her book report on where the wild things are. This was a parody, and it was inspired by the jailing of a 13-year-old. This is what happened with the 13-year-old. His English teacher gave the class an assignment to write the scariest story anybody could write. The 13-year-old went home and wrote a really scary story, and it scared the teacher to death. She ran down the hall to the principal's office clutching the essay, showed it to him. They called the police. The police showed up in the classroom, took the 13-year-old into custody, put him in cuffs, and a judge, the judge who's mentioned in this parody, ordered that he be held for psychiatric evaluation for 72 hours. New Times thought this was kind of a silly thing. The teacher, after all, asked for the scariest story a student could produce. They made up their own story about the 6-year-old. She had written this wild book review of where the wild things are. She would sit on her feet and she would blow bubbles into her milk. And for those crimes, she was being jailed. The judge and the DA both said, this is too real sounding. We're going to sue you for libel. The New Times moved for summary judgment, saying that it wasn't believable, but the trial court and the intermediate appellate court said, we're going to let a jury decide if it's believable or not. Eventually, it took the Texas Supreme Court to rule that the newspaper story was in fact humor, and humor that was not believable. It also has to be harmful to reputation, the third element of defamation. If someone writes or says or broadcasts something about you, or even posts it online, and you're embarrassed, or if you're hurt, or if you're annoyed, that doesn't necessarily make them liable. They have to damage your reputation. Damage to reputation changed considerably in the case of Peck versus Tribune from the previous century. Mrs. Peck is a teetotaler. She doesn't drink. She doesn't hang out with people who drink. One day she's walking down the street and she sees an advertisement. It has her picture, and underneath the picture of her is the legend, Mrs. Schumann drinks Duffy's pure malt whiskey. The rest of the ad referred to Mrs. Schumann being a nurse and talking about the wonderful restorative powers of Duffy's whiskey, saying that not only did she drink it, but she would give it to her patients. She sued. The trial court judge said, oh, tut-tut, no one would think less of anybody for drinking whiskey. I mean, I drink whiskey. Mrs. Peck appealed the decision by the trial court. It moved up the appellate ladder, and Judge Learned Hand, who was sitting on the bench of the appellate panel that heard the case, overruled the trial court judge, saying it's not a matter of whether or not right-thinking people would think drinking whiskey was good or bad. It's whether or not an important and respectable part of the community, Mrs. Peck's reputation in the temperance movement, would of course be hurt by allegations that she not only drank whiskey, but that she gave it to patients. With this, the American courts turned from an English approach to judging harm to reputation to an American approach. The English approach went like this. There's a fellow working in the trades. He's a house builder. Someone publishes a statement that attributes to him the sentiment that workers should be expected to work more than 40 hours a week without any extra money. As you might guess, his reputation with fellow workers was damaged. He sued the publisher of the statement. The case made it to the English courts, and English courts dismissed the libel claims, saying it's perfectly reasonable to understand that the working class ought to be doing more work for the fabulous wages that we're paying them. And so no right-thinking Englishman would think any less of this tradesman. In that case, in the English approach, they depend upon a patriarchal, upper-class definition of reputations and what would damage reputations and what would not. Judge Hand also said that a large number of people, a significant fraction, will now regard Miss Peck with contempt, and that's enough to do her harm. That's enough to harm her reputation. And he sent the case back down for reconsideration at the trial court level. You're going to be reading in your textbook about defamation per se and defamation per quod. These are terms of art. Don't worry about using defamation per se or defamation per quod. It just means defamation on its face or defamation that is apparent because of the context. It's not something that you'll have to deal with. It's for the lawyers to parse out. In defamation, things change. Things that would be considered harmful to reputation or not harmful to reputation change. A century ago, if you said that some fellow was gay, it was a compliment, meaning that he had a bright personality. In the 1950s and 60s, if you said someone was gay, you might get punched in the nose. Things change. In the 1950s, if you said someone was pinko or a communist, that would be defamatory, because that meant that the person being called a communist was sympathetic to the Communist Party as opposed to the American capitalistic system. The courts simply have to determine whether or not the words are generally understood as an attack on reputation. When you put words and pictures together, you can create a defamatory statement, as was found in Young versus New Mexico Broadcasting. In this case, a television reporter is standing in front of a business talking about other businesses of the same kind that do terrible things to consumers. The reporter's there saying, these businesses do this to consumers, these businesses do that to consumers. The problem was he was standing in front of one of the businesses that didn't do those things. It was one of the few that was behaving properly. Because the reporter was standing in front of the one identifiable business talking about how practices in that particular industry were harmful, that was enough to create a libelous statement. You know headlines, they're those big words, often not a whole lot of them, and they try to encapsulate and sum up a complex story in 4 or 5 words. Courts have come to the conclusion that headlines and articles need to be read together before you can determine whether they are libelous or not. In Las Vegas Sun versus Franklin, the newspaper ran a series on adoptions. Mr. Franklin was an attorney who assisted people with adoptions. There was criticism of Mr. Franklin's work. The headlines made it sound like Mr. Franklin was involved in the sale of babies. He filed a libel suit. But when you read the headline along with the article, you understood that he wasn't actually putting babies on the auction block and selling them to the highest bidder. The words in the article explained away and lessened the harm of the headline. And so, because you have to read the two together, Mr. Franklin loses. In television, those of you going into broadcasting, words and B-roll. B-roll is the video that you see before they go into the story. For example, a TV station is doing a story on high school students who are leaving the campus to burglarize nearby homes on their lunch hour. They're going to do B-roll as they introduce the story. In one case, I was contacted by a mother who said, local TV station did a story on high school students leaving the campus to burglarize nearby homes, and they had video of my daughter and 2 of her friends walking across the street away from the school. My daughter and one of her friends turned, and they both were identifiable in the video. I advised her that it looked like a libel case. The fact that it was B-roll, and in this case it was footage taken from an entirely different story, meant that it was less defensible for the TV station. And then we have teases. Those are the brief headlines that come before the commercial break. Because they come before commercial break, they're not necessarily read in connection with the entire story. Some people will change the channel. They'll leave the room to do whatever they need to do. And so you can't count on them putting the two together. Whereas with a headline in an article, it's right there on the same page. We'll take up injury in our next video.